The UCC1 is a security agreement on property that is recorded to protect the lenders or secured parties' investment. The basic information required in secured parties name, debtors, signature secured parties address debtors, mailing address statement indicating types of or describing the items of collateral. General notes in enforceable UCC1 should be typed. Many states will reject handwritten forms. You must provide two originals if you expect the state to return a certified in recorded conformed original back to you. Copies are not acceptable proof if you need to assert your sovereign rights to the system. Once you have filed this instrument, any multiple addresses of the debtor should be included as additional locations in the spaces provided. You will be charged an extra fee for each address. This is useful when you have lived in more than one state over the past 5 years. Make sure that state where your birth certificate was issued as well as in the state where you are now located. Although not required, we recommend you attach a copy of your birth certificate with your name spelled in all capital letters. Also, remember that most states require that you renew or refile the UCC1 every 5 years. Make sure it is always renewed and legally current. The fees for recording vary from state to state. If married, we also recommend both the husband and wife file a financing statement in the state where they were married. A wife should show both her married and maiden names as two separate debtors on the same financing statement. Her maiden name reflects the birth certificate persona, while her marriage surname, literally extra name, reflects her marriage certificate persona. Item C- here is where you will want the state to mail your second certified and file marked original to. Use proper English with upper N lowercase letters as shown. If you no longer have your own commercial address and are located in general delivery, use the commercial box or address of a friend. Before the street address, make sure you put care of signifying that this commercial address is not yours. Always place the federal postal code in brackets as shown. The rules of English grammar state that anything written within brackets signifies nothing. Item 1. Semicolon. This is for the debtor's information, your persona or straw man. Capitalize every letter, since this legally designates the artificial entity or persona it is commercial address. Make sure you include the Social Security account number, SSAN, number, and date of birth DOB. If a particular state form does not provide a space for DOB, enter it in the form somewhere else, such as within the description of the collateral. Capitalized middle initial with a period after it, such as John J. Smith in the debtor information area. Item 3. This is for the secured party information. The real you. Remember, use upper and lower case letters to signify your Christian name. According to the rules of English grammar, the real you does not have a commercial address. Show your location as general. Delivery at your local post office. A post office is not the same as the U.S. Postal Service. Never use a 2-letter capitalized federal designation for your state. Prior to introduction of the zip code in the 1960s, states were abbreviated with 3 or more letters, such as FLA, Tex, Mich, Con, or Mass. If you don't remember, ask your parents or grandparents. Again, put your federal territorial region code, zip code, in brackets. Item 4. Fill this in as shown or with very similar wording. If your state form has no provision for a separate DOB entry, put the DOB here also. Item 6. Only the debtor, your persona, is required to sign. Use all capital letters for this signature. You may sign it in ink with all capitals or simply type in the persona James Smith as you did in Item 1. Make sure you mark after the signature debtor so it's very clear which party has signed or placed their seal on the instrument. Find out from your present state and your birth state how much the filing recording fee is. Send a money order with the 2 originals to the address they give. Partville, summary, and conclusions. The most powerful contract in the world is the UCC1 financing statement. It's the ultimate modern-day legal foundation of commerce. It's the culmination and conclusion of a centuries-long refining process within commercial law. As all law is contract, this affidavit is the shining star of commercial legalism. All you are, all you do, and all you think is controlled by this legal affidavit. It quietly penetrates into your worldly life to control every aspect of your being. It has made you a servant and slave to the holder in due course of your life. It controls you and strips you of your God-inherent sovereignty. It has stripped away your freedom and liberty. It's your contract of complete servitude to the World Power Brokers WPB, the financing statement currently held by the real party of interest and holder against your earthly life. your past and future labors, and all your property and goods is absolutely legal and binding. The security instrument of this presumed contract is your birth certificate. The WPB bankers presently hold title to your persona and all that you are. You are the collateral for the debt held against your birth certificate. However, this contract was established by the legitimate and unlawful presumption, and it is an implied contract. Your failure to rebut, refute, challenge, or counterclaim against this presumption is the reason you have the current legal status of commercial chattel property. The WPB bankers have conquered and enslaved the world only because of the ignorance, apathy, and legal default of each person they hold in servitude. You are the only real being on the face of the earth with the legal right, knowledge, power, or duty to speak for yourself. Can assert your rights. No lawyer, attorney, agent, or representative can redeem your rights for you. If you fail to assert your rights, you have legally bound yourself and agreed to be a slave, subject to the wishes and whims of your taskmaster's mind. This is simple. Any future claims to a legal contract between you and attackers against your sovereignty is impossible because there never was a bona fide contract in the first place. This is because there was no mutual agreement made with full disclosure, a meeting of the minds, or good faith. You are, both legally and lawfully, the holder in due course of your own sovereignty. Whatever you choose to do or not do is always presumed to be your choice. If you fail to repel their implied contract that makes you subject to their system, they have on their side the legal rule of presumption that says you chose to act as you did, having full knowledge of the law. The exact same legal principles that have worked against you can work for you, but only when you rebut their presumption and reclaim your sovereign status. In all law, you are either a complete servant, debtor, or a purely sovereign creditor. There is no such status as a half-debtor or half-creditor. Laity dictates that there are two sides to all things, and this includes laws, rules, process, codes, and regulations. If any law is used in one way, such as against you by your default, it can also be used in the opposite way, such as by your correct use of them. A timeless and universal maxim of law states lex semper dabit remedium. The law always gives a remedy. The legal merchants of commerce must leave you a way out, a back door for escape. If they don't, then their legitimacy and legal authority becomes a sham, and this would destroy their purported law. No sovereign can rule without the majority consent of the people. Power always has in, always will reside in, and with the people. People become enjoined to servitude simply because they have chosen to give their power away rather than retain it, such as the demise in America. If a sufficient number of people in any country become aware of the truth and reclaim their power, no tyrant or government can maintain a sovereign position. Once you have filed a financing statement establishing the real and sovereign you as the this places you at the top of the list of creditors, number 1, numero uno, above the governments and their system. You have ownership to your persona, and no one can attach a claim to either of you. This makes you a legal sovereign, a legal freeman, and immune from all claims. We were not supposed to have knowledge or understanding concerning the open back door of legal remedy. Before 1862, Americans were personally accountable for their actions in common law courts based on the original common law of England prior to 1066. Currently, personae are legally owned property of the government and have become the accountable parties as prejudged and enforced by their private legal system and its rules. Former sovereign Americans are now personally accountable because they are joined by implied contracts to their straw men. The purported judicial courts of today are set up to deal only with artificial entities, such as your persona or a corporation.
Now, I will say that there are lots of people on this app that know what they're talking about, but mostly people don't know what they're talking about. Now, there are some channels on here that talk about how to discharge debt. And I haven't used these methods, but from all the receipts that they're posting, I'm sure that it works. So do your own research. But this video is about what I'm doing. And what I've been doing is I've been leaning shit. So first of all, in order to lien shit legally, you must own your Cesta QV Trust, your all caps name. You must own your birth certificate. You must claim it all back. That's all done through a UCC1 financing statement. Also, you need to incorporate a security agreement in that financing statement. And the security agreement is very important, the way it's worded and what it references. Also, you have to do a common law copyright on your name. You must do a legal notice and demand. And you have to incorporate all of these documents in your UCC1 financing statement when you lien your name. In addition, there's lots of other documents you need to fill out, the SS4, the Form 56, making, well, this is debatable. I've heard people say don't do this, but making Janet Yellen the fiduciary of the account. I've heard people say don't do that, but I've seen people do it and have tremendous results. So, you know, that's speculative. But I've been doing this information, researching this information for over 12 years. Even longer than that. It's been about 15 years, since 2007, really. And I've heard lots of different people. The information that's coming out these days is very eye-opening, and it's in alignment with the time space that we're in. Be it all is being revealed. Everything is being revealed. The highest forms of truth are being revealed. People's true nature are being revealed, be it family members, spouses, friends, co-workers. All of their true nature is being revealed. And you'll see that the information that's coming out now is very unique, because it hasn't been quite spoken about the way that it is these days. But my point is, once you've done this, you've followed all these steps that I've mentioned here, now you have legal recourse to lien anything that has your name on it, because you've copywritten your name, you've liened your name. I liened my name for $100 million. So I also put a $100 million bond on deposit with the Treasury Department. And that is accruing interest at 2% annually. So once you've done all this, you can lien things that have your name on it. So if you have a court case, lien the case number. The case number is tied to a financial account. It's a CUSIP number. The case number is a CUSIP number that's tied to your bond, aka your birth certificate, all tied to your Cesta QV Trust. So they created this account using your information that you currently own because you liened it. Once you lien that shit, the case is dead in the water, just based on my experience, based on pure logic, right? So a lot of these folks are telling you to discharge the penal sum, discharge the case, and there's various different methods that I've heard throughout the years on how to discharge the case. But instead of doing all that shit, I'm leaning shit. I'm leaning everything that has my name on it, and I'm claiming it. It's mine. It's mine. That's got my name on it. It's mine. Oh, you want to use my name? Check out my legal demand, my legal notice and demand. It says that if you're going to violate any of these itemizations outlined on my legal notice and demand, it's a $2 million fine, and it accrues interest every day that it's not paid. So go ahead, violate my rights, but I have legal recourse now, and I can't get in trouble for it. A lot of the people will get in trouble for placing liens on public officials if they haven't corrected their status, because you're not a secured party. If you're not a secured party, you're still a minor. They own your account. They own everything through claims, contract law. And this is how they get you to be subservient, is they wrap you up in adhesion contracts through coercion, and you're contracting with these folks, and in reality it's all a debt collection. It's all a tax, as Gene Keating would say. It's all a tax. So I started leaning everything. I leaned my car, I leaned my registration number, I leaned my license plate, I leaned my case numbers, I leaned my name, I leaned everything that's got my name on it. I'm leaning it. I own it. It's mine. It's mine, damn it. So if you go using my name without my consent, it's a $2 million fine. And if you don't pay that fine, then I have the right to lien you. And then I go start snatching up assets. So do your own research. I don't encourage anybody to take these steps without doing your own research. But I thought I'd throw that out there. Comment below. Let me know what you think.
Quit. Simply look back through his comments and mine. I finally figured out how to shut up these bootlickers. Ask them. You can't debate Supreme Court holdings because they do not know the difference or how to interpret legalese and English language. Quit. How to shut them down. Quit. Simply ask them, why does all courts, all of them, refer to you in your all capital letter name? From ab initio, from the first letter of the contract, from the first letter of the summons, from the first letter of the traffic citation, everything. Everything they refer to you in is the all capital letter name. Why do they not refer to you in your proper name, the way you sign it, the way you spell it? It shuts them down. Because everything is fucking contract and commerce. Title 28 U.S.C. 3002, Section 15A, the United States Federal Corporation, B and C, every city, state, and county, and police department is a subsidiary of that parent corporation. Shuts them down immediately because they ain't got a fucking clue how to respond. They misinterpret and misunderstand Supreme Court holdings because they don't know the definitions of words such as person. But I can't elicit another response from him since I started asking why, from ab initio, does all courts refer to you in your all capital letter name? He just quit. Because he knows he's portraying bullshit, perpetrating bullshit. The English language and Black's law are two totally different things. Judges, the courts, speak a different language than we do. It's not English. It's legalese. It's another language. Ambiguity. And people like this cannot decipher the difference between legalese and the common tongue, the English language. Imbeciles.
The fair warning thing I give everybody is, like I said, it's simple. I'll read it real quick because it's simple. I, and then you make your name, gave no entity the right to administrate my property. So it's like I, whatever your name is, Bob Johnson, gave no entity, known as the DHR, the right to administrate my property. So little old ladies like this, then they're trying to get their grandkids back from like CPS. So this is how I sent it to some lady. But you could use it for a car, you could use it for a tow truck, tow your car away, you could do it for anything. You just say, I, Bob Johnson, gave no entity the right to administrate my property. Number two, I say that, Baby Johnson is my property. This is what I was doing with little old ladies. I say that blank is my property. Number three, I say that no man or woman will make a claim saying my claim is untrue. Number four, I want my property returned to me. There you go. Number five, said properties to be totally under my control, post haste, within 3 days, whatever time limit you want to give them. And then number 6, it just says, I will charge the wrongful holder of said property X amount of dollars for every, whatever you want to do, every minute, every day said property is not returned, starting on the 22nd day after they've received this summons and this suit, see attached claim. So it's simple. You just make it simple. You just say, I give nobody the right to administrate my property. Number 2, I said that's my property. Number 3, no man or woman is going to come in open court and claim that my claim is untrue. 4, I want my property returned to me. 5, I want it done in like 2 days or less. And 6, I'm going to start charging you money. Because you're supposed to give them 21 days to answer a lawsuit. So on day 22, I'm going to start charging you, because within that 21 days, it gives them the opportunity to try to make a settlement with you on a private side.
And the 21 days gives them time to make a settlement.
Right. It gives them time to make a settlement with you on a private side. So then day 22, you're going to start charging. You'll see in court, and you're going to move it. You're going to move it before a trial by jury, and you're going to get it back.
Boy, I mean, they get tough down here. They're rough. I mean, they won't accept any paperwork or anything. I mean, that you can hardly even.
That's why you
can't believe nothing that these guys say.
Well, that's why you got to make it incredibly simple.
Peace and blessings. So on the back of your contract, you will see, notice, any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services. Therefore, you can assert the holder rule to the finance company. What are they talking about? They know this already. They know that if you take them to arbitration, they have to show up. I don't even know why they would tell you that. Okay? Peace.
I'm going to make this quick. I only got 3 minutes, so I'm going to get right to it. First of all, just for clarification, earlier, if you look at our background here, Collier County is in all capital letters. You look at the flag over there, all 3 of them are in gold trim. According to the National Flag, Title IV, Section 1 and 2, a yellow fringe is not authorized. It's a commercial entity. So when we did our Pledge of Allegiance, we did it to the commercial entity, not to the true American Republic, just so you know. The reason I'm here today is we strictly moved here to this community a couple years ago, almost 3 now, to investigate the county for corruption. We are welcomed here by open hands in the very beginning by Alfie Oakes, Patrick Dearborn, Bill, everybody. Once we started bringing out this information, I was blackballed by the Republican Party and everybody within the situation because, again, there's a lot of interactions that are taking place. The first interaction that I'd like to bring to the attention here and finalize is with the county clerk. Failure to operate outside the corporate structure, which violates her oath of office she signed. Failure to perform her duties as dual roles as a corporate entity and a constitutional officer. Failure to perform recording documents, a violation of federal statutes, 18 U.S.C. 2071, which I did sue the county as well as her for. Instead of moving it outside of the county, which they should have done because there's a conflict of interest, they dismissed the case locally here in the county. So, failure to perform her duties under the Homestead Act of domicile, giving people a choice. Failure to perform FOIA requests. This is the area of the Sunshine Law. When we ask for the names of each and every individual that works for the county clerk, position, salary, this is our response. As custodian of the public records for the clerk of the circuit court and comptroller for Collier County, I'm in receipt of your public records request. In response to your request, I have forwarded to a complete organizational chart of the clerk of the circuit court comptroller. She sent us an organizational chart with just the positions, with no names, no salaries, and said that she did not have to do this due to the fact that it was under a security statute. Okay, well, we did the same thing in several other counties throughout the state of Florida. Because again, because we sued her, I feel I'm being discriminated against because they're not bringing forth actual facts. So we asked Escondido County, Hillsborough County, Lee County, Manatee County, Miami-Dade County, which is the largest in our state, Pinellas County. Each and every one of them sent what we requested with no issues, no problems, no BS. So I'm here today to make you folks aware, because you are operating as a commercial entity. I am now a secured party creditor, which allows me to face and put liens against the county if I choose to do so, just so you know. And the only way you can take those liens away is through a court process. And we're going to be utilizing all of the records that you've been doing here for the last 2 years. I've accepted each and every one of your oaths except for the new 2 people that have been here. I'm accepting your oath of office today on a public record. You will also receive information directed to your home. So again, I'm asking for the immediate resignation of our county clerk for fraud and so forth.
Thank you.
Your next speaker.
Get in here, get in here, get in here, get in here. I'm about to expose a big secret. I'm about to expose a big secret right now. Get in here, get in here. So if you look at this document, it says Donald J. Trump plaintiffs versus the United States. Who is he going up against, right? You think this is the whole United States, but no, it's actually immigrants. Immigrants is suing us on our own land to say we done something wrong to them. Now, first of all, we got to understand the word colony. Colony was called states, okay? You have to understand that mentally. Do not take that out your head. The original states were New Hampshire, Massachusetts, Rhode Island, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. The original states, okay, were first 13 British colonies. Okay, so not talking about the whole so-called states, it's colonies. Okay, the colonies are suing us. That's it. That's one thing you can understand, just the colonies suing us. That's it. Now, if you look at this for a reference, let me explain it to you very clearly. So you can say, these peoples versus Secretary of State. So she the secretary for the colony. That's all she is, right? She the secretary for the colony, okay? This is who they suing, the secretary of the colony. Now, if you notice, it says the courts of appeal of the state, right, of Michigan, not the Michigan of state. It's the state of Michigan. So you see how they mirror the real peoples and still pretend to be of us, but they are a separate entity. So they are literally appeals of the colony. Remove the word state and just put the word colony. Now, if you look at this very closely, see this seal? It does not have the word state. And there's a good reason why it doesn't have the word state. Okay? It got the seal of Michigan because it's not a foreigner court. It's actually our court. Okay? Keep that in mind. Of the Republic. Okay? Of the Republic. This is why it's called a district. Now you're about to find out who actually owns America. Who owns the land according to the Iroquois Constitution? Women shall be considered the progenitor of the nations. So women actually own the court.
So yes, there is a special hack that you can use whenever you're trying to get approved for something. Apartments, cars, houses. Okay, ride with me on this hacking journey. So here are a few tips that I want you to take note of, pause to read, and let's get to it. So the first thing you're going to do is go to Google. You're going to Google Equifax Lock and Alert. You're going to Google this because if you notice, when you first try to do this, they try to get you to the wrong website. There are 2 different websites here, and one of them they want you to pay for. We want the free one. lockandalert.equifax.com. And this is what it looks like. You click sign up, enter your personal information, and you will have an account with a login. It's really that simple, but you have to know what to look for. That's the hack. The next one is TransUnion True Identity. That's what it's called. They also have other things that they want you to pay for. We want the free identity protection. It's 100% free, y'all. So if you see something that says that they want you to pay for it, no. Oh. So this is what you want. You want True Identity. That is the one that you're going to fill out the information for and sign up. And then once you have that and that login, you're good. Experian is not free. This one is going to cost you about $25 a month if you really want to protect your credit and have no one be able to pull it. But you basically go to this Credit Lock by Experian and sign up. As you can see, it's $24.99. Another option is you can just freeze your report. That's going to take a little bit longer to unfreeze, but this is a free way to do it. Back to the notes that I have. Then what you're going to do is you're going to start your research. You need to figure out whichever lender you're looking at, or whichever apartment, whichever house, any of those things. Figure out which credit bureau they pull or they want. So if you have all of them locked, what you do is you go in there and you ask them, which one do you pull? Whichever one they pull, that's the one you unlock, just so that they can pull it and lock that thing right back. This will prevent you from having multiple hard pulls whenever you apply for a car, if you choose to go to the dealership, or an apartment, any of those things, because you can control where they pull. Another hack is that if one of your credit reports is better than the other, say TransUnion is your best score, you can find a lender that only pulls TransUnion and they will only look at that. Follow me for more tips.
All right, y'all, I'm back with part 3 of 3 on how that contract paid for your car. So we already went over a consumer credit contract, the fact that it was an evidence of indebtedness, the fact that it was a financial asset. Now we're here with the last part on what they treated that contract as, that evidence of indebtedness as. Purchaser evidence of indebtedness is payable on demand or readily tradable. It was payable on demand because that contract was just as good as cash as soon as you signed it and got that vehicle. Treatment as payment. In general, a bond or other evidence of indebtedness is hereinafter in this section referred to as an obligation issued by any person and payable on demand, shall be treated as a payment in the year received, not as installment obligations payable in future years. In addition, an obligation issued by a corporation or a government or political subdivision thereof. So your financial institution is stealing from you, okay? Just like the dealership stole from you when they said that your financial institution or the creditor, really the dealership is the creditor, but we go over that in the down payment class, stole from you when they said that the financial institution required a down payment, but it was really the dealership. They're all